5 seconds to go. Start. In the second phase of the TIP, accused numbers 1 to 16 who were to be identified were mixed with 45 known suspects, with 31 of them being under trials and the remaining being civilians. Thereafter, PWs 10, 11, 12 and 15 proceeded with the identification. In the third phase of the TIP, accused numbers 1 to 19 were to be identified by PWs 8, 9 and 33. For identification, the accused were mixed with the pre-existing 45 known suspects. After the end of the identification process, accused number 2 on behalf of others stated that when accused numbers 1 to 19 were taken to court for remand and the presence of all the witnesses was arranged in the court by the police, he reiterated that while they were in police custody, they were photographed and videographed and were also made to be seen by all the witnesses from the chamber cabin of the IO PW84. All the accused collectively stated that they were wearing the very same dress straight from their arrest till the date of the TIP. All this is evident from the report of the identification parade of the 19 accused persons dated 26th August 2000. Thus, it can be seen that from the very beginning, the accused had objected to how the TIP was conducted and the events preceding it, which inter alia included the accused being shown to the witnesses from the cabin of the IO PW84, the accused being photographed and videographed while they were in police custody, securing the presence of the witnesses in court while the accused were produced for extension of their remand, and the accused wearing the same dress straight from their arrest till the date of the TIP. Upon completion of the investigation, including the TIP, as indicated above, charge sheet was filed on 23rd September 2000 and the case was committed to the Court of Additional District and Sessions Judge Fast Track Court 1st Thiruvananthapuram on 27th October 2000. On 26th May 2005, the Sessions Court framed charges under sections 120B, 143, 147, 148, 324, 427, 506, 302, 109 and 111 read with section 149 of the IPC and sections 32E of the PDPP Act against accused numbers 1 to 33. The prosecution examined 85 witnesses and marked 134 documents as exhibits. Thereafter, the defense examined 3 witnesses and marked 25 documents as exhibits. After hearing the matter in detail, the Sessions Court framed 12 points for consideration, which can be broadly classified into 3 issues: conspiracy hatched by accused numbers 1, 2 and 25 to 33, the murder of Rajesh, and the destruction of KSRTC buses and other public properties. To establish a conspiracy case against accused numbers 1, 2 and 25 to 33, the prosecution examined PW68 and PW85. PW68, who deposed before the court that he had overheard the conversation between the accused hatching the conspiracy. PW85, on the other hand, turned hostile. Therefore, based on the deposition of PW68, the Sessions Court convicted accused numbers 1, 2 and 25 to 33 under sections 120B of the IPC, read with section 32E of the PDPP Act, sections 109 and 111 of the IPC, and sentenced them to 4 years of imprisonment. In appeal, the High Court disbelieved PW68 and consequently set aside the conviction of accused numbers 1, 2 and 25 to 33 under the above mentioned provisions. The decision of the High Court on the issue of conspiracy against accused numbers 1, 2 and 25 to 33 has attained finality, as the state has not preferred an appeal. Insofar as the issue relating to the charge of murder of Rajesh against accused numbers 17 and 19 is concerned, the prosecution relied upon the evidence of PWs 5, 6 and 8. These witnesses deposed that while accused number 17 bait Rajesh with an iron pipe, accused number 19 bait him with a wooden reaper. Based on the deposition of PWs 5, 6 and 8, the Sessions Court convicted accused numbers 17 and 19 under section 302 read with 34 of the IPC for life. The High Court in appeal set aside this conviction and instead found them guilty under section 326 read with 34 of the IPC and sentenced them to 7 years of rigorous imprisonment. The finding of the High Court on this issue has also attained finality, as the state has not appealed before this court against the altered conviction and the reduced sentence. In fact, even accused numbers 17 and 19 have not appealed since they had already served a sentence of 7 years. Stop.